Welcome to SpringLaw's Spring Forward Legal Updates webinar series. This series is designed to provide a comprehensive legal overview of key issues related to employment law and human rights in Ontario. SpringLaw is a virtual employment law firm advising on workplace legal issues for employers, employees, freelancers, and executives from a wide range of industries. We hope you enjoyed today's webinar and find it useful and informative. To reach our team, please visit us at springlaw.ca. And now to our presenters.
Hi, good morning, welcome. I'm Jessyca Greenwood. I'm a partner and litigation lead at SpringLaw. Joining me today is my colleague, Emily Sue. And if you are one of our clients, you already know that we are employment and contracts lawyers. I also do some criminal defense work, and we're a virtual law firm based in Ontario. For those of you who are new, welcome, and thank you so much for joining us this morning. Feel free to ask us questions after by email. You can also download some of our helpful resources on our website. We've got an award-winning weekly blog post for you to check out, some free resources, including an employment contracts checklist, a link to subscribe to our monthly newsletter, and we also have a subscription program for employer clients. So with that said, we will get started. And if you miss anything, you will receive the webcast in a video format for you to watch at a future time. So feel free to just enjoy today and don't worry about taking notes. So we will get started. There's the two of us there. First of all, I'd like to acknowledge where we're joining you from today. I'm joining you from Toronto, and we are on the traditional lands and the territories, including the Mississaugas of the Credit, the Anishinaabe, Chippewa, and Haudenosaunee and Wendat peoples, and that this is a territory in Toronto that's home to many First Nations urban Indigenous persons. And so we like to acknowledge that today. We do also need legal disclaimers because what we're about to go through with you today is not legal advice. I won't read that, but take a look at it. I'll turn it over to Emily for our roadmap.
Thank you, Jessyca. So let me give you a bit of an overview on what we're going to talk about today. First of all, we're going to speak about the who, what, and how of litigating when you're in the employment law context. And then we're going to move on to some tips on how to save money and time, because litigation can be a very lengthy and expensive process. And then we're going to talk about the why and how of avoiding litigation. And we're going to speak about settling versus going to a hearing and which one is the best option for you as an employer. And if litigation can be avoided, we're going to speak a little bit about that and what happens if you get caught up in litigation and there's no way around it. And finally, we're going to give you some of our key takeaways and final thoughts. So the who, what, and how of employment litigation. The who. So normally, you have employers and employees, as well as in a labor context, you have management and you have the union. This webinar is geared toward employers that are faced with litigation in a non-unionized context. And in a non-unionized context, the employee is typically the plaintiff or the applicant, depending on what forum they pursue. And the employer is typically the defendant or the respondent. Sometimes these two roles will switch up, but normally this is how litigation is structured in employment law. So what typically leads to litigation? Could change the slide.
There we go.
Perfect. So there are many scenarios that can lead to litigation. Here we've outlined some of the most common ones that we've seen. So an employee might claim that they're entitled to more notice than they've been provided in a wrongful dismissal. There may be workplace harassment claims, claims about violations of human rights, and breach of contract as well, which engages the previous three situations, but there could be other terms, whether in an implied or an express contract that one of the parties is claiming has been breached, or one of the provisions that have been breached. So there are several avenues for taking legal action. The first very common one is to file a claim at the regular civil court. And if the total value of the claim is more than $35,000, normally the employee or the employer in some cases will pursue that through the regular civil court, superior court, for example. And then if the total value of the matter is less than or $35,000, then the party will often file a claim with the small claims court. An employee might also file an application with the Human Rights Tribunal in Ontario or a complaint with the Canadian Human Rights Commission if the main issue is a human rights violation. Another option for employees specifically is to file an employment standards claim with the Ministry of Labor to address breaches that are specific to the minimum standards legislation. So in Ontario, that would be the Employment Standards Act 2000. So if the employee is missing overtime pay or there's some sort of violation of the Employment Standards Act 2000, that's the avenue that they can, that's one of the avenues that can pursue the rights.
Just to pop in there, it's often an employee will call the Ministry of Labor. The ministry has a number of resources available on their website for employees to report things like unpaid commissions or harassment allegations that weren't investigated, or some form of workplace safety issue or a reprisal. So those are some examples of when an employee might call, and the Ministry of Labor will send out an inspector who may make orders and look at the situation and look at what has happened and what's appropriate. That doesn't necessarily lead to the traditional form of litigation, but it certainly can cause a lot of stress for employers and cause employers to have to get legal counsel and engage and be able to respond to those types of orders that the ministry might make.
Absolutely. And these are, that is a reason why it's important to make sure that you as an employer are complying with all of the requirements of the Employment Standards Act and to avoid the situation occurring. Another avenue, and I won't go too much into this, is with respect to an individual that's employed by a federally regulated employer. And this employee can file different types of labor standards complaints with the labor program, such as monetary complaints, or some of them non-monetary complaints, unjust dismissal complaints, genetic testing complaints. It's not uncommon for employees to self-represent without a lawyer, or mostly on their own, but with a lawyer coaching them in the background, giving them some behind-the-scenes advice for all of the options that we've laid out here, except for civil actions, in order to keep their costs down. So that's something to keep in mind. That is one of the options that an employee has.
One of the unique features of being a federally regulated employee is that your employer can't terminate you for the circumstances under which they can terminate you are very limited, and they certainly have to have, if they say they're terminating you for cause, they have to actually have cause. So that leads to some complaints using the Canada Labour Program as well. And that can be a forum where the employee can move forward with a complaint on their own. It will be managed by a labor specialist who's a federal employee who manages these programs. And if they don't settle, it will go to arbitration, which is kind of like a court hearing, but using the labor program. So we're going to talk now a little bit about the civil litigation steps and what this looks like. In a lot of cases, employer clients haven't been to court. They don't know what is involved or what that might look like. And I hope for all of you that you never have to go to court, that your contracts are solid, that they don't get challenged, and you don't have to go down this road and through this process. But it's good to be aware of what this looks like and how it unfolds. So the way that a litigation matter will start is usually by the issuing of a statement of claim. And there is a limitation period. The limitation period is 2 years. That period of time was extended somewhat by COVID. So if something happened during COVID, there was a bit of a hiatus and people get some extra time to file claims that arose during the lockdown. So ask us about that if you're concerned at all about limitation periods. But the statement of claim is issued and it's served on the parties. So imagine you get this at your workplace, a process server shows up with an envelope and they hand it to you, and inside is this document that says you're being sued. And statements of claim usually set out generally the facts of the case and how the plaintiff establishes their lawsuit. So whether it's wrongful dismissal or breaches of the Employment Standards Act, or there's human rights allegations contained in that statement of claim, the core allegations are supposed to be in that document, so you understand what it is that you're being sued for. What has to happen then, and this is a pretty quick turnaround, is that a statement of defense has to be issued within 20 days of receiving that statement of claim, unless you file a notice of intent to defend, which gives you an extra 10 days for a total of 30. This means that you have to find a lawyer. Your lawyer has to get up to speed on the case and draft a statement of defense. If you think that you will be sued, you want to get advice from a lawyer in advance of that and not leave it until you get the statement of claim. Even if the lawyer's just in a holding pattern or just waiting, it's better to have them on board and know that this might be coming. If you know that you're going to be sued, you may also have obligations to report that to your insurer, perhaps to your professional regulatory body. So keep those considerations in mind as well. Once the statement of defense is ready and it's served on the other parties, the plaintiff has a right of reply. And then from there, the pleadings close. Once the pleadings are closed, we can move on with the other litigation steps. We can talk about whether or not there should be offers to settle. We can schedule examinations for discovery, which are questioning of the witnesses. There's a requirement in certain regions, including Toronto, that there be mandatory mediation. And there's a big push for that mandatory mediation to be rolled out province-wide. That's a change to the rules that's probably coming. But for now, we have mandatory mediation in Toronto and several other centers in Ontario. Once you get through that process, if there is no settlement, then we're looking at having a trial. So there may be motions. There's the exchange of documents between the parties, both before examinations for discovery and after, in answer to various questions that may have been asked. And then the matter gets set down for a trial. Usually there's some case management conferences that happen to talk about whether or not the matter can resolve, and also the time required for a trial. In civil court, you are looking at probably getting a trial somewhere between 12 and 24 months away, depending on the length of the trial. So that means that this is going to drag on for some time. And it's certainly a reason why employers should consider whether or not they wish to go through and go down that process. And there's a bunch of factors that we're going to talk about in the balance of the webinar that you may want to take into consideration. Those are generally the steps. And then lastly, if the trial did not go your way and you need to revisit the decision of the judge, you would bring an appeal, and that generally goes to the Ontario Court of Appeal, depending on which forum you were in, or divisional court. So there's lots of process, lots of steps involved, and this is why it's good to have a lawyer, have advice and a strategy, and don't leave things to the last minute to get advice. Okay, so we have next the small claims steps. Small claims court is meant to be a court for people who can generally represent themselves. It has a simplified process over civil procedure. You don't get to have examinations for discovery. You're not having a jury trial in small claims court. It is meant to be an expedited process. So you have the same start of the process. The forms are available online, and there's some very good resources if you have to go to small claims court available on the government website, and some various other represent yourself types of websites. So take a look at that if you do have to go through the small claims court process, or definitely speak with us. We are happy to help with this. But the initial process to get the claim going is the same. And then what happens is the court will reach out and say it's time for us to have a settlement conference. There's lots of room in there for the lawyers to speak between themselves and have discussions about whether or not the matter can settle. And failing that, you will meet with an associate justice, or used to be called a master, and the judges will sit you down or meet with you virtually and talk to you about the case and see whether or not the matter can settle, or if it has to be set down for trial. If it is set down for trial, it's meant to be a speedier process. So you're exchanging witness lists, documents you'll rely on, and then the matter goes ahead and there is a trial. Anything to add to that, Emily? I know you've been in small claims court recently.
Yeah, so before the pandemic, a settlement conference could normally be scheduled within 1 month of the close of the pleadings. But after the pandemic, it's been 6+ months. So expect that the process is going to be prolonged as a result of COVID and a huge backlog that the court currently has.
Some factors to consider when you're looking at litigation, and I often hear this from clients when the matter is fresh and they are embroiled in the conflict that's going on between the parties. I hear, I want to fight this, I want to take it to court. And it's quite a common reaction, but after careful consideration and a look at the cost, we generally say that the math of going to court doesn't really add up. And it depends on the value of the claim and how much money is in play, and what that looks like, and also what the issues are. But I would say on balance, the cost of going to trial is usually more than settling the claim. There's also a factor of your time that's involved. If you as a business person are taken away from doing your job to focus on winning the case, means that you're going to spend a lot of time organizing documents. You may have to be prepared to testify. You might have to take employees out of your workforce and interview them and prepare them to testify. There's a whole host of a diversion of resources from doing the work of your business to preparing for trial and then actually going to trial. A lot of people don't realize, but there's a lot of waiting around at court. Sometimes when you're having your trial, it doesn't always start on the first day. Sometimes you're waiting for a courtroom or a judge to be available. You may be waiting around at court for 2 or 3 days before your matter actually starts. And so a lot of times people don't realize that these delays are something to consider, because it's definitely a downside to litigation. You also have the factor of cost awards. If you lose the litigation, you can be on the hook to pay part or a substantial amount of the other side's cost of the litigation. So there's that. That's a definite downside and a risk. There's also the unpredictability. Court has a human factor. Your audience, the person or persons who will be making the decision, are human. They may find the employee to be sympathetic and find the employer to be having done something that you didn't expect. You didn't expect to be found that you had done anything wrong because you believe you didn't. So there is that unpredictability about who will be believed, whose evidence will be found credible or reliable or not. And then the delay, if the trial doesn't go ahead for what might be a year and a half or 2 years, is that important? Does this result need to come to a conclusion in order for your business to move forward?
So for human rights claims, which is one of the other categories, one of the other forms through which an employee can seek legal recourse, there has to be grounds that are engaged here. So in accordance with the Ontario Human Rights Commission under the Ontario Human Rights Code, employees can claim discrimination on these grounds, and I'm not going to go through them, and you can just take a look at it. But there are quite a few, and some which employers may not necessarily turn their mind to because it's not talked about that frequently. And the protected grounds or prohibited grounds, as they are referred to under the Canadian Human Rights Act, this is for federally, for in a federal context, those are comparable to these ones under the Canadian Human Rights Act, with the exception of a few differences in language. But in order for an application to be made at the Human Rights Tribunal in Ontario, for example, at least one of these grounds have to be engaged. There has to be some sort of discrimination on the basis of one of these grounds. And there are a variety of different steps, as you can see in this chart, for a human rights application. And you can take a look at that. And in the interests of time, I won't go into it too deeply. But normally, especially in Ontario, the Human Rights Tribunal doesn't enforce an employee's minimum standards or common law rights. So this may not be the best path for an employee, and this is not a path that an employee might take if the main issue is something like a lot of unpaid overtime pay or outstanding notice pay. The main job of the Human Rights Tribunal is to enforce the Human Rights Code and to provide compensation to the employee for violations of their human rights. And the tribunal can order a variety of different things, like getting the employer to create a human rights policy or undergo human rights training. Sometimes, and this is something that is a little bit scary for employers, the tribunal can even order reinstatement of the employee. So the employer actually has to give the employee their job back. Not an attractive option for many employers, so it's important to ensure that that you can do what you can in the workplace and with employees to ensure that human rights violations are avoided. And also of note is the Human Rights Tribunal can order that the employer pay lost wages. This is often a little bit different from notice pay in wrongful dismissal cases. If the employee had expenses like counseling that are related to the human rights violations they experienced or the discrimination they experienced, then the Human Rights Tribunal can order that employer repay the employee for something like that, for those sorts of out-of-pocket expenses. But the Human Rights Tribunal's main job is to determine whether or not the employee's human rights were violated or they experienced discrimination and how much they should get in order to compensate for that.
One thing to add there is an interlude for mediation, but the parties have to agree to it in the human rights context, and you will be assigned a either an alternate chair or a member of the Human Rights Tribunal who acts not in an adjudicative function at the mediation, but as a mediator. And I've had some success both on the plaintiff side and on the defendant side of settling matters at an HRTO mediation. So that's something that is involved in the process and can be used to settle the matter. But it's also worth thinking about that if it goes to a hearing, those decisions can be public. They're published online on Canly. And if there is allegations of human rights violations, that's something that a business might want to think about from a PR perspective. So looking at tips to save money and also time, we've talked a little bit about this already. I've spoken a bit about the human capital that goes into preparing for litigation. But one important consideration I think all businesses should look at is having litigation insurance. I'm not being paid by any insurance companies to make that recommendation, so I'm not getting any kickbacks here. But I will say that my clients who have litigation insurance were able to feel comfortable meeting with me and using the time they needed with me because they knew their insurance company was covering it. And what that meant was there's different types of insurance. There's general insurance if a client or a customer slips and falls at your business, but then you can also buy extra insurance and riders that cover if you're sued by an employee, if there's a breach of contract, if there's defamation and you have to sue. So take a look at that. There's also errors and omissions and directors and officers liability insurance. Try to make sure that you have adequate coverage. And if you have grown into a bigger business and you've got 10 or more employees, you really are in a situation where you might have an employee who has to be terminated, who might sue. And it's good to think about these potential situations up front and have a buffer in your budget and have the insurance that you need up front and before an issue like this arises. So I urge you to please take a look at getting litigation insurance, and if you can, make sure that you have it. In terms of saving money and time, if you have a case that's going to litigation, the lawyer needs a chronology of events and all of the evidence that you have that you say supports your position. If you are our client and you want us to be able to give you good advice, solid advice, and develop a strategy that helps you win the case or settle the case favorably, I really need all of that information up front. And so the more you can do to save emails and PDF documents and put them in files in a format that's going to be useful for court, that is a huge time saver. It's a money saver. It means that you as the client aren't forwarding me 400 emails that I then have to sort through and organize and bill you for. So the more that you can do to organize using Google Drive or Dropbox and keeping the documents in folders in chronological order, that is incredibly helpful. It helps me absorb the information and be able to give you appropriate advice and a strategy. Also, I would say at the beginning, a lot of clients are not open to settlement. And again, it depends on what the issues are in the case. You may have a very strong case, but be open to the possibility of settlement, especially where the case could be settled for a minimal amount and save a lot of time and stress for the company and those involved in the litigation.
So in the blurb that we provided, that we attached as part of our promotion for this webinar, one of the topics we indicated we cover is how to avoid getting into litigation in the first place. And we've already covered that a little bit, but we didn't address the why of that. And for some, that might be obvious. For others, less so. For example, avoiding litigation may not be apparently obvious in terms of why that should be the case. If you have an employer that is fairly new to this process and might be very personally invested in an employer or employee dispute. But oftentimes, seeking legal recourse through the judicial system may not be the best option. And why is that? Well, we've already discussed a little bit about this, and Jessyca has done a great job in outlining some of the main points. Just to reiterate, there are costs that are involved. Litigation isn't something that is going to cost, normally it's not something that's going to cost a few $1,000s. It could run up to tens of thousands of dollars or hundreds of thousands of dollars. And if you do a cost benefit analysis, it may not be worthwhile. And there could also be cost consequences that the employer will have to face if they are the losing party. And time, it is a lengthy process. It is stressful for many people. At first, it may not seem that way, but once you go down the road of litigation, it becomes increasingly stressful for many, especially given how long it drags out for. And it's difficult on a business, especially if it's a small business and the person who is dealing with the lawyer to go through the litigation process also has to run the business. And there's also the publicity and public relations aspect of this. And, once you go to trial, all the skeletons come out of the closet, how you run your business, everything is looked at. And that's really important to think about when it comes to the reputation of your business. So the best practices to avoid litigation, number one, seek advice before acting. When it comes to a termination, for example, if you think you're going to fire an employee, it's best to speak with a lawyer so you know how to do it properly, what to consider, and what the risks are of whatever approach you take. Also, right at the outset, you want to provide employees with employment contracts. So this is at the hiring stage. And you want to make sure that you don't just take an employment contract that you find online. The jurisdiction could be wrong. Wrong. It could be incorrect. It could be in the US. Canada has a fairly complex employment laws, and you want to make sure that you have a termination provision that's solid and that's enforceable. And employment law in Ontario and in Canada evolves very quickly. And so a contract with employment with a termination provision that was enforceable 3 years ago may not be enforceable now. So when you try to limit an employee's entitlements to the amount that's set out in the minimum standards legislation, that may no longer be enforceable. So you're on the hook for a lot more. So that's very important, and be open to compromise and settlement. It's just part of the cost of doing business.
I see that we are basically at time, so I'm going to move quickly through the last bit here. We have talked a lot about what it looks like to try to resolve a case without litigation. What I would highlight is that it's very important to understand the strengths and weaknesses of the case. Some cases are so strong and the other side is just wrong, and there is no settlement that can be reached. I love those cases. I love to litigate. I love going to court. I don't want to talk you out of going to a hearing if you have merit. But we do have to acknowledge that there's strengths and weaknesses. There needs to be a strategy up front. And I encourage you, if you're involved in litigation now, to consider whether or not you have a solid strategy and whether or not it's worth it for you to continue with the litigation or settle. If it's worth it, then full steam ahead. Get a litigation budget, get a commitment from your counsel, from your firm about what the costs will be. And if you're prepared to invest, move forward full steam ahead. And we've talked about all of these cost-benefit analysis, and I'm happy to always talk with clients about managing reputational concerns and how to different strategies to make sure that everything you're doing in litigation is protecting the business and reducing exposure as much as possible. So I'll let Emily take us through our key takeaways.
Thanks, Jessyca. So in terms of some final thoughts, it is best to consult a lawyer before making significant decisions about the workplace if they impact workers. And this goes beyond having enforceable employment contracts. If an employee engages in misconduct, it might be useful to sit down with a lawyer just even for a brief chat to determine what the best course of action is, and to avoid any sort of disciplinary action that is in breach of the law. And it's always worthwhile to spend a few $1,000s upfront to make sure that you're doing the right thing as an employer, having enforceable employment contracts in order to avoid a $10,000, $50,000, $100,000 problem down the line when things go south with an employee. Making sure your I's are dotted and your T's are crossed right at the outset can assist you with making sure that you can reduce your risk and avoid litigation.
I think the main point there is just be proactive. It can save you from having litigation at all.
Absolutely. And that concludes today's webinar. Our webinar series pauses during the summer months, and so the next one will be on Wednesday, September 21st, at 10:30 a.m. And stay tuned for the fall-winter lineup via our newsletter and our website. And as Jessyca mentioned at the beginning, feel free to follow up with us with any questions that you might have. Thank you so much for joining us today.
Thank you again, and have a great day.